Good morning, everyone, and welcome to our presentation. Thank you for joining us. My name is Alexis Pennell. I'm with Orchid Advisors, and I am going to get us kicked off this morning. If you'll notice on the right side of your presentation screen, you have the opportunity to raise your hand or ask a question. Please feel free to utilize those at any time during the presentation. So to get us started right away, I wanted to introduce myself. My name is Alexis Pennell. Like I said, I'm the Executive Director of FFLBizHub.com. My co-presenter today will be Phil Milks. He is the Executive Director for the Manufacturing Practice here at Orchid Advisors. And prior to joining the Orchid Advisors team, he was with Remington. This presentation is done on behalf of the NASGW State Compliance Program, and just a reminder that the program is free to all members of NASGW, and if you'd like more information on the program, please reach out to NASGW or myself so that we can get you into the program and taking care of, getting access to these outstanding benefits. During today's session, we are going to touch on a few topics here. Federally, we're going to go over ATF updates and information from 2017, as well as NICS enhancements, export control reform, and then delve into some state legislative and regulatory updates, as well as various pending legislation. We're going to jump right in here to the federal firearm regulatory updates from 2012. Specifically regarding ATF Form 4473, as the industry is no doubt well aware by this time, in January, the new 4473 form was required to be utilized. In May of 2017, ATF was able to update their E4473 application to align with the revised ATF Form 4473. So anyone that would like to use that application now, beginning in May, it is updated and ready to be utilized, aligned with the new form. In May, the Spanish version of the 4473 was also posted for comment, and final comments were due in August of this year, but the publication date has not been determined as of yet. So hopefully, early next year, there will be a Spanish form of the new ATF Form 4473, but again, at this time, only available in English. In 2017, we also saw some big information updates from ATF as far as disaster preparation. They did issue 3 special advisories, specifically around Hurricane Harvey, Irma, and Maria. And one of the strong recommendations of all 3 advisories was that FFLs should have a disaster preparedness plan to safeguard their business, and specifically said firearms and ammunition, as well as explosives and required records, should be safeguarded during any sort of anticipated disaster, as well as having a preparation plan for that disaster. It also stated that licensees should be very proactive when it comes to protecting required records, including contacting their local field office in order to remove things from FFL premises, including firearms or ammunition, Forms 4473 or multiple sales reports, any theft loss reports, etc., as well as your acquisition and disposition records. These documents went so far as to say, if absolutely necessary, a field office could give verbal authorization for movement of these records, which is a wonderful thing, and I strongly encourage anyone with an FFL to be sure they've walked through some of these disaster preparedness suggestions, have thought it through, and I believe that NASGW has some information available on the website specifically to what to do prior to a disaster during and in recovery mode for federal firearms licensees. ATF also issued Procedure 2017-1. As exciting as this sounds, it is specifically focused on FFLs facilitating private party transfers. This is very relevant because a lot of it had been a bit ambiguous regarding when to acquire or dispose. And with this guidance, they've made it very clear and is definitely applicable in states that require an FFL facilitate. Excuse me, the processes in Procedure 2017-1 are specific to the response you're given to a background check. If you get an immediate proceed, you would complete the 4473 as usual, indicating in question 23 that it is to facilitate a private party transfer. If the background check response is denied or if it's canceled or a like response, if the seller has not relinquished possession of the firearm, they may leave with the firearm, and the FFL does not have to enter the acquisition into the A&D book. However, if the private party seller leaves the firearm in the possession of the FFL at the FFL business premises, so in other words, customer says, here it is, I'm going to sell it, and leaves it with you, then the firearm must be acquired into the A&D book, and a 4473 must be completed for whether the return or the sale of the firearm. And even if it is for the person who had presented it for sale, they must go through the 4473 process, including a background check. And the firearm must be acquired and disposed appropriately in the A&D. If you get a delay response or a like response to a background check without a denial, the private party seller may leave the FFL premises with the firearm if he or she has not relinquished possession of the firearm. There is no acquisition entry required. However, the seller must return to the dealer to transfer the firearm to a prospective buyer. So if customer and associated buyer come in, the associated buyer is given a delay and they decide to leave the FFL premises to complete the transfer of the firearm to the buyer, they must return to the FFL premises. If the FFL agrees, the seller may leave the firearm in the possession of the FFL pending a background check response and/or a waiting period. However, the FFL must acquire and dispose of the firearm according to all regulations. Good news, though, is that your seller doesn't have to return to FFL premises to complete the transfer. Big note here, if the private parties do not return to complete the transfer, you must retain the 4473 in accordance with all ATF regulations. So whether or not the transaction goes forward or is ever completed, you must retain the 4473s appropriately. If you get a delay and are subsequently given a denial, it goes back to if the private party seller hasn't relinquished possession, they haven't left your FFL premises, then you are not required to acquire and dispose of the firearm. However, if the seller has left the firearm in the exclusive control of the FFL on the FFL premises, the firearm must be acquired and disposed just like a standard firearm sale, if you will, and complete a 4473 for the return to the original seller, including the appropriate background check and waiting period. It requires that a proceed or no response within 3 business days and all appropriate waiting periods are observed. So just because the person previously possessed the firearm, once they leave it in an FFL's possession, you must go through all of the normal processes to dispose of a firearm to a non-licensee. Takes it a little further within this procedure regarding handguns. If the seller doesn't relinquish control of the handgun, then you are required to give a secure gun storage device, so a lockbox, if you will, or a safety device such as a trigger lock for each handgun intending to be transferred. In addition to that, multiple dispositions acquired in 5 consecutive business days of handguns, whether it is the original seller and you've had to redispose of the firearms to this person due to an incomplete intended disposition, or whether it is the buyer, these are considered multiple sales and must be reported appropriately. In addition, long guns also require the same multiple disposition reporting for 5 consecutive business days, again, regardless of whether it was the original intended seller or the buyer. FFLs must also comply with all applicable state and local laws. So there's no exemption just because that FFL is facilitating the private party transfer at that point. So all age requirements are in place as established with the Gun Control Act, including 18 years for a long gun, 21 years for a handgun or any other weapon. And state requirements must be adhered to so if you're trying to transfer to residents of different states, etc., just because you're facilitating a private party transfer doesn't mean it's outside of all of the normal regulations in your area for transferring a firearm to a non-licensee. So all private party transfers that an FFL facilitates should be conducted identical to any over-the-counter sale. Moving on to FBI NICS, they did announce in May that they have added some enhanced customer service hours. They are now available Monday through Thursday from 12 p.m. Eastern to 5 p.m. Eastern. They do remain closed on Friday, Saturday, and Sunday. However, they do have a new Ask the FBI NICS for Assistance form online. I highly recommend you utilize this form given the opportunity. I understand they've had some great response times to this, as well as the form is available 24/7, so you can get your request in the queue for a response, even if they are not accepting calls at that time. So I think this is a great tool, and I do encourage anyone needing assistance from FBI NICS to utilize it. Touching quickly onto export control reform, it is still up in the air as far as final implementation. The State Department has completed the necessary revisions to the ITAR. However, the Commerce Department has not completed the revisions to the Export Administration Regulations and all of the steps that are required to receive the items being moved from the ITAR to the EAR. Therefore, until this process is outlined, everything just remains status quo. So yes, are there changes coming? Absolutely. However, until the Commerce Department irons exactly what that will look like out, everything remains the same, and we don't have an anticipated date of completion or introduction of this at the time. That sums up a lot of the federal level regulatory changes. I will now hand over the presentation to my co-presenter, Phil Milks. Phil?
Hi, thank you, Alexis. Can you hear me?
Yes, sir.
All right, excellent. Just wanted to make sure I had some trouble joining this at the outset, so I missed the beginning, so apologies. So thank you, Alexis. Again, my name is Philip Milks. I lead our manufacturing practice. Pleasure to be here speaking with everybody this morning. I do recognize some names from the attendee list, so it's nice to see those names, and some other ones I don't recognize. It's a pleasure to speak to you today. So beyond leading the manufacturing practice at Orchid, I'm also involved with creating some of the tools in the FFL Biz Hub, including the state restrictions tool. And Alexis, we could switch to that. Thank you. So the state restrictions tool, I just want to explain this prior to going into the legislative update or summary real quick. So first of all, this is free for NASGW members. If you'd like access to this, or if you'd like to ask any questions about this after the presentation, you can feel free to contact either Alexis for access to it, or if you want to speak about the tool a little bit more, what it does, you can feel free to contact me directly as well. What does this tool do? So this version is the public version, again, free for NASGW members, and it allows people nationwide to determine what type of firearms are prohibited in what locations. Obviously, we have all 50 states in there. We have District of Columbia in there as well, and we do have some cities in there like Los Angeles, New York City, etc. So again, you can come in here, you can search for what firearms are legal where. You can either run a nationwide open search, where in the country is this firearm prohibited, or you can run a search in a very specific jurisdiction, is this firearm prohibited in that jurisdiction. What you do is you go in, manually select what type of firearm you're dealing with. You can see up in the, just to the left of the NASGW thing, there's a rifle selected, and you're going to go down, you're going to select your options. Semi-auto, pump, center fire, rim fire, detachable mag, fixed mag. After selecting those introductory matters, you're going to go into your features. What quote-unquote bad is on the firearm? Do you have a folding stock? Do you have a grenade launcher? Do you have a bayonet lug, etc.? After that, you're going to click search, and you're going to get your results. Is it prohibited here? Is it not prohibited here? In addition to identifying where it's prohibited, you're going to get a listing of all the applicable statutes, and you can see that behind the blue text box there. You can see it lists all the California Penal Code sections, and you can go in those. You can click those. It's going to take you to the state's website. If you're so interested, you can read the statute, maybe see what else is exempted there on those statutes. What doesn't the tool do? I just mentioned exemptions. So you're not going to get exemptions listed on the screen. Many reasons, but essentially exemptions are, limited on a case-by-case basis. It'd be impossible to narrow down what exemptions may be applicable to any given situation. Obviously, all jurisdictions, you have your exemptions for sales to law enforcement, etc., so those are always going to apply. Oftentimes, when you are selling to FFLs in different locations, FFLs are exempted from most assault weapons or large capacity mag bans. So really what this is a consumer facing, not a consumer facing tool, but a tool for FFL to determine what they can sell to consumers in certain locations. In addition to not listing exemptions, it's not going to list any sales process restrictions, i.e. does a person need a license in a state, for example, to purchase any given firearm. And again, this tool is free for NASGW members, and if you'd like access to it, you can call Alexis. So with that being said, that goes into the next slide, please, Alexis. Okay, so legislation adopted or effective in 2017. So let me give you a few notes prior to jumping into this. So first of all, this is not meant to be encompassing of everything firearms related that was passed nationwide or proposed nationwide in 2017. Every year there's thousands upon thousands of bills impacting the firearms industry nationwide. So it'd be impossible to even spend 8 hours with you guys all day and go through everything that was either proposed or pending. So what did I include in here? I tried to include what most directly impacts the industry. So I left out a lot of the Second Amendment stuff, like you can carry in a park or you can carry in school districts or not, open carry restrictions, things like that. So with that being said, what I've included here is obviously subjective. There may be something in here that you are aware of that is not included. I may have probably made a conscious decision not to include it for one reason or another. So with that being said, I'll get into it now. So California, Prop 63, although not passed in 2017, its provisions go into effect over the course of 2017 through 2019. What is included in here was an outright prohibition on large capacity magazines, so requiring California residents to surrender any magazine that they owned at that point in time that was over 10 rounds. So no longer were the grandfathering provisions available to California residents. You can see on there that I've noted that there's litigation pending on that, and I'll touch on that a little bit later. Section 8 of Prop 63 added these ammunition vendor licensing and ammunition sales restrictions. So the net result of that is to be able to sell ammunition in California, you have to obtain an ammunition vendor license, much like a California firearms dealer license. And California residents may no longer purchase ammunition online from out of state. They can still, or out of state and ship it directly to their home. They can still purchase ammunition online. However, much like firearm purchases online, that ammunition has to be shipped to either a California Firearms FFL or a California quote-unquote ammunition vendor, where they will go then pick it up in a face-to-face transaction. Regarding assault weapons and large capacity magazine regulation, in 2016, the quote-unquote Gunmageddon provisions were passed, Senate Bill 880 and Assembly Bill 1135. Those new provisions were effective January 1 of 2017. You'll also see I've noted there that there is litigation pending on those, which again I'll touch at after going through all the proposed legislation. Essentially, this quote-unquote strengthened the assault weapon definitions in California, removing the bullet button exemption, restricting, further restricting what firearms Californians can buy. You'll see there was a little bit of a debacle with the assault weapon regulations. The DOJ proposed them, then withdrew them, proposed them again. They were rejected by another administrative agency in California. Then almost identical regulations were proposed, and that other administrative agency allowed those to be adopted with very minor changes from the original proposal that was rejected. Again, litigation is pending on those, and I'll describe what's going on with that litigation at the end of this. Iowa House File 517 legalized possession of short-barreled rifles and short-barreled shotguns in Iowa. So those consumers in Iowa can now enjoy those, and it opens up a little bit of a new marketplace for retailers, distributors, and manufacturers of SBRs, SBSs. Massachusetts, very recently, I believe in the beginning of November, the first week of November, when they passed their budget, they included a bump stock ban in that budget bill. Excuse me. So obviously that is prohibiting Massachusetts residents from purchasing, possessing, obtaining bump stocks after the effective date of that bill. Maine is remove the requirement for retail dealers to make separate copies of their 4473s, small change. Minnesota, this has got an asterisk. They didn't pass new legislation, but the ATF announced it's recognizing Minnesota carry permits as qualifying for the NICS exemption. Texas House Bill 1819 revised the Texas statutes in a couple minor ways. One, it now tracks federal law regarding suppressors. So this was really to preempt passage of the Hearing Protection Act at the federal level, which is now stalled for political reasons. Prior to this amendment, you had to register suppressors with ATF if you were a Texas resident. Obviously, if HPA passed, you wouldn't be able to register those suppressors, so there would be no way to comply with Texas law. This amendment changed that. And B, it also clarified that non-NFA short-barreled firearms are permissible to own, like the Mossberg 590 Shockwave. Prior to this, there were split of authority even amongst attorneys in Texas as to whether those firearms were available for sale or not to Texas residents. This makes it clear that they are. And finally, Washington House Bill makes an incumbent upon firearms dealers to report to law enforcement any denied firearm transfers involving prohibited persons. So those are the major quote-unquote direct impact of what's been adopted or effective in 2017. And again, that's slightly subjective. If anyone has any questions, I'd be happy to field those at the end or offline after this is over. Or if you have any questions about something that you realize was adopted in 2017 that I did not include, I'd be happy to discuss that offline as well. Okay, so pending federal, there's a lot listed here, as you can see. There's probably about another 175 firearms-related bills pending in Congress right now that are not listed here. I'm largely going to skip over this for the following reason. Very little chance of almost anything in here passing, whether it be the Firearms Federal Firearms Licensing Protection Act or any of the, pretty much anything else on here is anti-gun. Given the makeup of Congress, notwithstanding the political climate of the recent tragedy, not much in here has a chance of passing. So, obviously, the first three bills were a predictable response to the Vegas tragedy, all deal in various forms with prohibiting bump stocks, trigger cranks, etc. The problem with these is the language used to prohibit those items. So the language is very broad. I'm sure most, if not all of you, have heard something about this, and that the language could result in banning simple firearm upgrades, such as a trigger upgrade. You know, some legislators have been wise to point that out, and that's really what has stalled these, essentially, because everyone after the tragedy was on board with, you know, prohibiting those bump stocks, but now given the legislative language, that's all stalled. The Senate Bill 2095 introduces a new assault weapon ban that also includes bump stocks within its language. It also prohibits large capacity ammunition feeding devices. Does provide for exemption for manufacturing to buy and sell to, you know, military, government, law enforcement, etc. Stop Online Ammunition Sales Act, relatively straightforward. Keep Americans Safe Act, despite its title, prohibits large capacity magazines, anything over 10 rounds. The next two bills provide for different waiting periods to purchase different firearms. First one, House Resolution 4018, the 3-day waiting period before a person can receive a handgun, and the Gun Safety Not Sorry Act proposes a 7-day waiting period prior to transferring any semi-automatic firearm, any suppressor, armor-piercing ammunition, or quote-unquote large capacity magazines. The next two bills brought in background checks, the first one to any firearm purchase, i.e. universal background check, and the second bill removes the 3-day exemption to the NICS check. So if you've received a delayed response from NICS, that bill would remove the ability to transfer that after 3 days, business days passed. The Fire Sale Loophole Closing Act, this removes the ability of a licensee after their license has been revoked or their renewal application has been denied to transfer that business inventory into their personal inventory. It also restricts them from ability to, receive additional quote-unquote business firearms. I'm not going to touch on all these in the right column, just the first couple, actually, in the interest of time. I can see we're almost running over already. The Secure Firearms Storage Act, thankfully, it has very little chance of being passed. If it did, it would have a massive impact on all types of FFLs. It identifies very specific storage requirements and security requirements for firearms in an FFL's inventory. So at the end of every single day, a retail dealer would be able to be forced to secure firearms either by a bar and a lock or by putting them in a vault. And that would also apply to manufacturers. So manufacturers, apparently, with hundreds of thousands of firearms, or tens of thousands, or just a few thousand firearms in a facility, would be forced to lock all those in some form of vault. Obviously, that would be a tremendous burden on many manufacturers across the country, but again, thankfully, very little chance of being passed. I'm going to skip the next one, which pretty much just brought in the multiple sales reporting to all firearms, and just touch on the Federal Firearms Licensing Protection Act. Excuse me, that would increase penalties for theft, burglary of firearms from the premises of an FFL. And then the next one, the Equal Access to Justice for Victims of Gun Violence Act, would be very detrimental to the industry. It would repeal the protections of plaque-ups. So again, thankfully, that has very little chance of being passed. If anyone would like to speak to any of the remainder of these on here, I'd be happy to do so offline, or if you have any questions at the end of this. But again, very little on here has chance of being passed. So I'm going to, in the interest of time and not going too far over our allotted time, I'm going to breeze over the remainder of those. All right, so in the states, seeing essentially the same thing nationwide in all states, and that is targeting bump stocks, a renewed push on assault weapons and large capacity magazines. Florida, you can see there's a bump stock proposal. Again, like the federal proposal, this is there's an issue with language that could include, many types of firearm upgrades. So it'd be very, very broad and onerous to comply with. Florida has also introduced an assault weapon and large capacity magazine prohibition. Making life a little bit easier for Florida FFLs is House Bill 55, which is directing the Florida Department of Law Enforcement to implement a system whereby FFLs can electronically pay for background check fees. And Florida has also introduced a universal background check bill, which you'll see in the next slides. A couple other states have proposed as well. Georgia, House Bill 651. This is pre-filed. It's going to be formally introduced in 2018. Again, ban on bump stocks. This one is narrower in scope than the other bump stock proposals across the country, but it could be construed, I guess, depending on the court, on what other parts it could include within its prohibition. All right, you can see that Illinois went all out in proposing a ton of new laws. You can see that 5 of them relate to bump stocks because one bill was not enough. One of the bills was recently voted down in committee, or excuse me, I think it was before the whole House. I think it was, check my notes, it's 4117, assuming my notes are accurate. That was recently voted down, but as you can see, there are 2 other bills in the House and 2 other bills in the Senate currently pending that are all aimed at prohibiting bump stocks. The House Bill 715 is a state preemption provision. It provides that local units cannot require registration or sales reporting of firearm registries, and it would nullify any currently existing municipal provisions that mandate those. House Bill 3178, FOID repeal. I assume there's very little chance that that is going to be passed, although I'm not intricately involved in the Illinois legislative process. I don't see Illinois removing the firearms owner identification card. That is currently in committee. There's no votes have been taken on that as well. The other major item of note here, excuse me, in Illinois would be House Bill 4127. Now, this repeals the state assault weapon preemption provision. So essentially, there's a statute in Illinois' books that says, regulating assault weapons are the jurisdiction of the state. This would repeal that, and it would allow local units to, pass a smorgasbord essentially of assault weapons bans as they see fit. There are municipal assault weapons bans in the state of Illinois, but all of those that are currently on the books were grandfathered prior to that state preemption provision. Like the other bills in Illinois, this one is in committee, and there's been no votes taken on it yet. Next slide, please, Alexis. So, like Illinois, Massachusetts went all in on a slew of anti-gun bills. I've already referenced that in the budget bill. They included a ban on bump stocks. So you can see House Bill 2495 mandates liability insurance for gun ownership. I'm not sure of the exact extent of that liability insurance, what amounts must be carried, etc. I can imagine that is creating a lot of heartburn in Massachusetts. 2, I'll say, quote-unquote pro-gun bills, House Bill 1310 and Senate Bill 1322 removes the ability of the Massachusetts Attorney General to regulate assault weapons. as well as Senate Bill 1316. Each bill does it in a little bit of a different way. Many of you may recall that last year the Massachusetts Attorney General put out an enforcement notice on what she considers quote-unquote assault weapons under the Massachusetts statutes. There is currently litigation pending on that, which I'll touch on a little bit later. These bills would attempt to remove her authority to broaden or regulate assault weapons. You can see there's three bills regarding suppressor ownership. Proposals to allow ownership of suppressors in Massachusetts. Another pro-gun bill, 1325, repeal the assault weapons statute. I'm not hopeful that's going to pass as well, given the political climate in that state. There is a universal background check proposal. There's a House Bill 1285. It just minorly tweaks the definition of assault weapon. Senate Bill 1298 is a pretty lengthy bill and very important. There's two tax levies included in that bill. There's a 4.75% tax proposed on all retail sales of ammunition, firearms, and parts thereof. There is also a 4.75% tax proposed on the storage, use, or other consumption of ammunition, firearms, etc. So that would, obviously affect firearm sales. There'd be additional taxes, additional tax returns. That would very negatively impact firearm manufacturers in that state as well. And finally, the last bill, regulates the process for firearm rentals, puts forth a NICS-type check for firearm rentals, and has provisions regarding universal background checks as well. New Hampshire state preemption provision. Various municipalities in New Hampshire have recently started proposing and passing firearms bills. This just clarifies that is the province of the state. New Jersey proposed a bill to regulate .50 caliber or over firearms as destructive devices in that state. It does provide a provision to allow people who currently own those to register those as well. Also, there is a proposed bill in New Jersey, like the other states, to prohibit bump stocks. And again, problem with that bill is the broad language. And finally, there is a bill to propose the prohibition of online ammunition purchases, require purchases of ammunition to occur face-to-face in a retail shop. New York and Ohio, all four bills all propose to prohibit bump stocks. Again, the language is very broad on those. Those are all in committee yet. No votes have been taken on that. What I will say with respect to New York is I recently saw statements from the New York State Attorney General as well as the New York State Police that they already consider New York law as prohibiting bump stocks. These seek to make it clear that the state does in fact prohibit bump stocks. Whether the current law does or does not, obviously a little bit of ambiguity there between how the Attorney General is going to enforce that and what the legislators think the Attorney General can enforce. But I would not be willing, if I were in New York, to test the limits of that prohibition or non-prohibition. Next slide, please, Lex. And finally, we can essentially skip over all these just because they, again, all propose bump stock bans. You can see for Virginia that has a proposal for universal background checks. And these are all, again, very broad bans that could prohibit much more than bump stocks. And I believe all of these are still in committee, and there have been no votes taken yet on any of these. So as far as pending legislation goes, many other states, just on a closing note, have discussed proposing bump stock bans. A lot of state legislatures are not in session at this point in time, and they haven't been since the since the tragedy that occurred in October. So you can expect next year to probably at the beginning of the year, probably pre-shot, to see a slew of proposed bills prohibiting bump stocks, prohibiting trigger modification devices, etc. Okay, Alexa, next slide, please. Now, regarding litigation pending in California. So these 4 suits are relate to, again, the new assault weapon ban and the new large capacity magazine, quote unquote, seizing, I'll say. So the first one is a constitutional challenge to the new large cap magazine laws. This is a federal district court case. The federal district judge in this case, 2 days prior to the forfeiture law going into effect, issued a preliminary injunction. So essentially, the California state authorities cannot enforce the requirement to forfeit all large capacity magazines. That is currently pending. The appeal of that is pending in the Ninth Circuit right now. So if the Ninth Circuit overturned that preliminary injunction, they would be able to enforce the forfeiture provisions. I'm not entirely sure where the Ninth Circuit's going to land on that. I would not be surprised either way, given the extremely detrimental effect to people's personal property on the one hand, and on the other hand, you have the competing factor of the Ninth Circuit's generally off-the-wall views on pretty much any law. White v. Percara, that was also a constitutional challenge to the same law. That was another district court in California. Preliminary injunction request was denied in that case, but again, the preliminary injunction issued in Duncan v. Percara applied statewide. Ruff is a constitutional challenge to the new assault weapon laws, or Gunmageddon, however you guys have heard those referenced. Right now, there's a scheduling conference set for December 1, which basically sets the timetable for how litigation is going to proceed, when motions are due, when trial is due, when trial begins, etc. And Villanueva v. Percara is a challenge to the regulations, not the law itself, but the regulations issued to implement the new assault weapon laws. So if you recall from the first slide, there was a kind of an embarrassment of riches on the anti-gunners trying to issue those regulations, and the plaintiffs here are seeking to have the regulations permanently enjoined from being enforced as a violation of the other California laws, namely the Administrative Procedure Act. All right, Alexis, next slide, please. And this is the last slide I have to speak to. Colby versus Hogan in Maryland. This was a lawsuit challenging Maryland's assault weapons ban and large capacity ban that was issued in the wake of Newtown. So this has been pending for almost 4 years now. You can see I've noticed here that SCOTUS recently denied certiorari. So this has kind of an interesting history. The district court granted the state's motion for summary judgment, dismissing the lawsuit, saying the ban is okay, essentially. The Fourth Circuit panel on appeal decided that the district court decided the case wrong, essentially reviewed the case wrong, applied the wrong law to overbroaden what they stated. Now, this would have been a pretty substantial win for people, the gun rights crowd, but the state appealed that to the larger Fourth Circuit to hear that en banc to essentially overturn the panel of the Fourth Circuit. That appeal was granted, and the greater Fourth Circuit, the en banc, overturned the prior Fourth Circuit panel's decision. What that did was essentially went back to the district court decision and said that the district court did decide it right, and that those laws are in fact constitutional. So a little bit of a cloudy history. It was at first a big win for gun rights people, and then very shortly thereafter, it was a substantial loss for the gun rights crowd. And then again, SCOTUS decided, and the net result of that is the assault weapons and magazine bans stand in Maryland. And finally, Pullman v. Healy is a complaint which is challenging the Massachusetts Attorney General's enforcement notice. I've not seen any motions or histories on this, so all I can say right now is that this lawsuit is still pending. Okay, again, a selective choice of pending legislation, pending lawsuits. If anyone would like to discuss anything that was in there or not in there, anything that is in your state currently pending that you've heard of, I'd be happy to discuss that offline. My contact information is on this deck. You can feel free to reach me by email is probably best. So with that, Alexis, I will turn it back over to you.
Absolutely. Thank you, Phil. Everyone, if you have any questions, again, if you look on the right-hand side of your webinar control panel, you can either type a question or raise your hand and we can answer those for you. We have gone a little bit over time today, so moving right along, we won't ignore your questions, just waiting for some to come in. But I wanted to say thank you on behalf of Orchid Advisors and FFL BizHub for letting us be a part of the NASGW State Compliance Program, and remind you as well to definitely reach out if you don't know about all of the benefits of the NASGW program. Please reach out and we'll get you some more information. The handouts are available. Again, on the right-hand side, you'll notice some handouts, including this presentation, which has these useful links of data reference. And with that, being that we don't have any questions right now, Kenyon, I am going to turn it over to you for some closing remarks.
Sure. Thank you, Alexis. I appreciate it. I appreciate the opportunity to have this webinar. It's a lot of information you guys covered today, and clearly there is a lot of stuff happening that is in the works or could potentially happen. And the best place, of course, to keep up with all of that is through this program and this partnership that NASGW has with Orchid Advisors. You can get into the state compliance portion of the website and keep up to date on all of these developing occurrences. Of course, we'll certainly come back to you all with further updates in the future. Easy for me to say. Further updates in the future as they become available. But this is a great partnership. Certainly hope that all of you as NASGW members take advantage of it. Really happy with the partnership with Orchid, and it continues to develop into a great way to get information about this ever-changing environment of legal and compliance issues. So, Alexis, to you and Phil and everyone, John, everyone at Orchid, thank you for what you do. Thank you for being a partner with NASGW, and good luck on keeping track of all of these things as we move forward.
Thank you very much.
We need a little bit of luck for sure. Thank you, Kenyon.
Definitely. Thank you. And with that, we are going to close our webinar today. You will get a poll once we're completed, so please let us know how we did and any suggestions you may have for making this better. Appreciate everyone for sharing your time today, and thank you. That's all for me. Phil, anything you'd like to add?
No, again, thank you everyone for your time. Sorry I was a little bit long-winded. I tried to go through it as quickly as possible. I know some of it's a little bit dry, but again, we'll keep everyone updated through the NASGW compliance program, and wish everyone the best, and hope to see everyone in a couple months.
Thank you, everyone. Enjoy your afternoon. Bye-bye.